part 2 of the intellectual property laws series, and this time we focus on the law and patents. Just to give historical background on patents and legislation on patents, it was actually the precursor of our modern patent system began in England in the 12th century. So England po to. So persons who introduced a technology imported abroad was granted an incentive which was called then as letters patent. Okay, so letters patent means an open letter. Okay, it gives unto him monopoly powers or the sole right to use it for a period enough to establish a new industry. So it is shielding him from competition during the formative years of his new undertaking. Okay, so subsequently what we have is after 12th century, the Treaty of Paris in the Philippines. Okay, so this is in 1898. So it provided there in the Treaty of Paris that copyright, trademarks, and patents that were granted by the Spanish authorities, to Filipinos continue to have legal effect in the Philippines. So technically, from Spanish law English sa atin, then Spanish law to the Filipinos. Okay, and then in 1913, we also have the U.S. patent laws. This was observed then here in the Philippines. And technically what happened during the time is that U.S. patent laws found applicability in the Philippine Islands in 1913, I repeat. Then we came now to 1947. 1947 is significant because by virtue of Republic Act 165, the Philippine Patent Office was actually established. And again, to connect it with what we are now learning will be the Intellectual Property Code, which took effect in 1998. Okay, so ayan po yung historical background natin. And when we talk about IP, intellectual property that relates to technological advances, what we have will be those laws that would cover patents, like what we are to discuss now, industrial designs, layout designs, protection of undisclosed information. So ang focus natin will be this particular portion of the Intellectual Property Code, the law on patents. So patents, so when the patent is granted, the details of the patent are entered into the patent registry. The registry, usually contains bibliographic data such as the patent number, the name, and address of the applicant or the patentee, the name of the inventor, the original application number, the filing date, certain priority application as details, and the title of the invention. It does not contain any technical information. Yan po yung laman nung sa registry. So registry here would of course be with the Intellectual Property Office of the Philippines. So mamaya pag-usapan natin kung ano si patents, which was actually mentioned already in this slide. So patent says here, it is a right that is granted by the state to an inventor to exclude others from commercially exploiting the invention for a limited period of time in return for the disclosure of the invention. You give me this much protection, in return I will disclose to you my invention so that others may gain the benefit of the invention. The disclosure of the invention is thus an important consideration in any patent granting procedure. So kaakibat yun nung obligation actually nung protected inventor to disclose the information that he has concerning his invention. Note that while the state may grant patent rights, it does not automatically enforce them. It's not automatically enforced. It is up to the owner of the patent to bring an action, usually under civil law, for any infringement of his patent rights. The patentee must therefore be his own policeman. Patent. look at this. Here are examples of maybe inventions that have now earned the protection by having been registered before, of course, our intellectual property office. So, whenever you get it registered at na-record sa registry, ito po yung certificate na matatanggap. Okay? So, it's an invention. Patent, invention. Related terms po yan. So, next will be which inventions are patentable. Okay? So, inventions, ano bang inventions muna? Inventions are new solutions to specific technical problems. That's how we understand inventions. An invention may relate to a product or a process. Okay? And the protection that the law confers on this patent is limited in time. Okay? Mamaya-maya tingnan natin. But I guess generally 20 years po yan, the protection. Okay? What else on patents? Which inventions are patentable? An invention must meet several criteria if it is to be eligible for patent protection. These include, most significantly, that the invention must consist of a patentable subject matter and that the invention must be industrially applicable. Okay, industry applicable, we have to understand it as useful. It must be new, novel. It must exhibit a sufficient inventive step. Okay, so it should be not obvious, non-obvious. Okay, and that the disclosure, as we have mentioned in the previous slide, okay, there should be disclosure of the invention in the patent application. Okay, yun po yan. So, new, inventive step, industrially applicable. Or inventive step, new, industrially applicable. INI. Okay, that's your acronym for you to remember this. It may or may relate to a product or a process or an improvement of a product or an improvement of a process. So, next will be what types of inventions or ideas can be patented. So, connect muna natin kanina sa ating brief description. In order to be patentable or rather eligible for patent protection, an invention must fall within the scope of patentable subject matter. Okay, may scope of patentable subject matter po yan. Patentable subject matter is established by statute and is usually defined in terms of the exceptions to patentability. The general rule being that patent protection shall be available for inventions in all fields of technology, okay, of the TRIPS agreement. Okay? Yung isa pong WTO agreement po natin with other states. The TRIPS agreement, it is in conformity with that. Okay? So, ano po? If you are to take a look at this particular patentable inventions, any technical solution to a problem in any field of human activity, which is against INI. Okay? New involves an inventive step and is industrially applicable. Okay? The invention may be or may relate to. Okay? Ano ang idadagdag natin dito? Okay? Improvement of a microorganism and non-biological and microbiological process. So, it's really technology. Requirements on obviousness and inventive step. Okay? An invention, novelty muna tayo, the first characteristic. An invention is new if it is not anticipated by the prior art. So, may technical term tayong gagamitin dito sa batas. Prior arts, okay? Anong ibig sabihin ng prior art? Prior art is, in general, all the knowledge that existed prior to the relevant filing or priority date of a patent application, whether it existed by way of written or oral disclosure. So, kung ano yung status quo bago nag-file ng application for patent registration, yun po yung prior art na yan. It should not be obvious to persons during that particular point in time. Okay? So, in other words, okay, if we are to talk about being, am I still here? Okay. An invention involves an inventive step. Okay. Okay, that's the period of time that we relate to. Okay. Let's take a look at some. problems. X invented a method of improving the tenderness of meat. Okay, so this must refer to a process. By injecting an enzyme solution into the live animal shortly before slaughter. So bago papatayin ay may ini-inject. Okay. Is the invention patentable? Is this the invention that we are talking about that may be subject to patent protection? Okay, meron ba siyang characteristic na ini? A novel, inventive step, industrially applicable. Would it involve an invention in any field of technology? Okay, what's your answer? Okay, natin to. To be patentable, the invention must be new, okay, as we have been mentioning a while back, and should consist in a useful machine, manufactured product, or process. The one in red is very important. Among those that cannot be patented are processes which are not directed to making or improving a commercial product. Viewed from the above light, itong ating criteria, okay? Itong listahan po, is it a patentable subject? Okay. Viewed from the above light, X may lawfully patent his invention. Okay. What about this one? Samsung invented a cellular phone that can also play digital music or MP3s. It applied for the issuance of letters patent. What do you think? Doon sa definition ulit natin ng patentable subject matter. Ini. Okay? The invention is patentable because it combines existing elements, a cellular phone and a digital music player, and produces a new and useful result, namely the convenience of having two gadgets in one. Patentable. So pag titingnan natin, usually baka ang question na makikita ninyo, ang mamimit ninyo ang maibibigay sa inyo kung patents man ang maging subject matter ng IPL. Okay? It may actually delve into this, meeting the criteria, okay, to make this subject matter patentable. Si ini po, alalahanin niyo po si ini. Okay, let's take a look at this example. Okay, we have this. It happened about 4 years, I think. 4 years ago. Okay, a senior student. Tignan niyo, naka-invento po siya. Technically, it's part of their curriculum. Okay, and their research po nila to come out with this. Okay, inventions. Okay. Tignan niyo po. It does away with fluorocarbons as cooling agent. And of course, it's industrially applicable. Okay. It's new. Okay. It involved an inventive step which was not present, okay, sa prior art bago to nangyari. Okay. Which items shall be excluded from patent protection? Okay. Sa listahan, nangunguna po ay discoveries, scientific theories, and mathematical methods. So, ano po bang ibig sabihin ng scientific discovery? It is said that scientific discoveries are not the same as inventions. A scientific discovery is the recognition of phenomena, properties, laws of the material universe not recognized and capable of verification. Okay? So, ayan po yan. Kaya excluded siya dyan. What else are excluded from patent, registration, or protection? Schemes, rules, and methods of performing mental acts, playing games or doing business, and programs for computers. The methods for treating of the human or animal body by surgery or therapy, and diagnostic methods practiced on the human or animal body. Okay? So, exempted po yan or excluded. Except, kung sa except clause natin, it will be the reverse of where this item is belong, di ba? So, pag except products and composition for use in any of these methods that we have mentioned, so ito po yung patentable na subject matter. Okay, yung product, yung composition. Okay? Yan. But not the method. Yan. So, mapapaisip kayo sa pag-come out ng bakuna laban sa COVID, ano doon yung patentable, ano doon ang hindi patentable. Okay? We continue with our list. So we also have here plant varieties or animal breeds, or essentially biological process for the production of plants or animals. And similar to the analysis that we have for the third excluded item for patent protection, microorganisms and non-biological and microbiological processes are patentable subject matter. Aesthetic creations are not inventions, thus would not enjoy patent protection. And the TRIPS agreement, which we mentioned previously, further specifies that members of WTO may exclude from patent protection certain kinds of inventions. For instance, inventions that the commercial exploitation of which would actually contravene public order and morality. Naisama po natin itong provision under the TRIPS agreement sa Intellectual Property Code. Let's take a look at this problem. Okay. Dr. Nobel discovered a new method of treating Alzheimer's involving a special method of diagnosing the disease, treating it with a new medicine that has been discovered after long experimentation and field testing, and a novel mental isometric exercise. He comes to you for advice on how he can have his discoveries protected. So tatlo po yun, no? Can he legally protect his new method of diagnosis, the new medicine, and the new method of treatment? If no, why? If yes, how? Yan po yung tinatanong ng problem natin. Okay. So, on the question of can he legally protect his new method of diagnosis, okay, is covered by the yung second paragraph ng sagot natin. When we talk about the new medicine, it's actually covered by the first paragraph ng sagot. New method of treatment is also covered by the second paragraph of the answer. Okay, so Dr. Nobel can be protected by a patent for the new medicine as it falls within the scope of Section 21 of the Intellectual Property Code, meaning kasama siya doon sa listahan ng batas. Okay, yung nasa listahan ng batas also is also related, similar to, nasa listahan po ng TRIPS agreement. Okay? But would not enjoy protection. Okay, so no protection can be legally extended to him for the method of diagnosis and the method of treatment which are expressly non-patentable. Okay? Nakita naman po natin ito sa listahan natin kanina ng those that are excluded from patent protection. Another, X invented a bogus coin detector which can be used exclusively on self-operating gambling devices, otherwise known as one-armed bandits. Can X apply for a patent? For a patent. Alam yung sagot, no? Okay. X may not apply for the patent since the gambling device mentioned in the problem itself is prohibited and against public order. But if the machine is used in legalized gambling, such as cases of exclusive use of casinos established by the government, such device can be patented. Okay. What about this problem? Supposing that Albert Einstein were alive today and he filed with the Intellectual Property Office an application for patent for his theory of relativity expressed in the formula A equals mc squared. Okay? The Intellectual Property Office disapproved Einstein's application on the ground that his theory of relativity is not patentable. Is the Intellectual Property Office action correct? Sa tingin ninyo? Okay. Ang lumulutang po dito sa problem natin ay theory. Okay. Yan. Tama ba ang denial ni Intellectual Property Office dun sa kanyang application? Yes. The Intellectual Property Office action is correct. Okay, that the theory of relativity is not patentable. Under this provision of our code, discoveries, expressly mentioned there, discoveries, scientific theories, and mathematical methods are not patentable. To whom does the right to a patent belong? If the patent registration, application for patent registration is approved, to whom should that right belong? Okay? The right to a patent belongs to the inventor, his heirs, or assigns. When two or more persons have jointly made an invention, the right to a patent shall belong to them jointly. Okay, so co-ownership, parang ganun, no? So if the patent is created pursuant to a commission, nabayaran sila, the person who commissions the work shall own the patent. It's a general rule, unless otherwise provided in the contract. So kung may kaibang usapan na nakapaloob doon sa contract na pamumumisyon. Okay? Baka sinabi, hati tayo. Diba? Baka sinabi, 60-40. Anyway, that would answer to whom does the right to patent belong. Okay. Who owns the patent for an invention made by the employee in the course of his employment contract? Okay, take a look at the qualifying conditions. In case the employee made the invention in the course of his employment contract, the patent shall belong to A, the employee. Under what condition? If the inventive activity is not part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. Hindi siya part ng kanyang regular duties, then it is patentable. Okay, to the employee. To the employer, on the other hand, if the invention is the result of the performance of his regularly assigned duties, trabaho niya yun. Okay, it's general rule. Unless, again, similar to our previous slide on commissioning, there is an agreement, express or implied, to the contrary. Okay. What is this rule? First to file rule. If two or more persons have made the invention separately and independently of each other, magkaibang interest sila, the right to the patent shall belong to the person who filed an application for such invention. So who applied? That's the first rule. Where two or more applications are filed for the same invention, okay, to whom? Sino po ang bibigyan ng priority? To the applicant who has the earliest filing date or the earliest priority date. Okay? So, i-apply mo. Tapos, titinan natin. Okay? Kung sabay kayo nag-apply, earliest filing date or earliest priority date. Okay? First to file rule. So, what is the scope of patent protection? If you're granted patent protection, what does it cover? To what extent? The scope of patent protection is defined by the claims which are to be interpreted in the context of the description and drawings. In determining the extent of the protection conferred by the patent, the element that is equivalent to the element expressed in the claims will be considered, so that a claim is considered to cover not only all the elements expressed therein, but also the equivalents. So technically, it would tell us that it would cover which is claimed in the application. Okay? So, makikita din po ito kung doon sa patentable subject matter, sa listahan mismo ng batas, nakapaloob doon kung ano yung in-applyan at ano yung extent ng kanyang coverage. Okay, if it says there that it can also cover equivalents ng ating in-applyan, then that will be the extent of the patent protection. So, ito na. Administrative complaints for violation of patents. An administrative complaint is issued by filing a verified complaint with the BLA of the Intellectual Property Office within 4 years of the date of the commission of the violation, or if the date is unknown, from the date of the discovery of the violation. So 4 years, yung period po natin to file an administrative complaint. Okay, so 4 years ang period, reckon it from when? Okay, date of commission, pag hindi alam kung kailan, date of discovery. Parang similar din po sa rules natin sa tax, just in case, no? Only that here we have 4 years. Okay. Civil action for infringement. Paano naman po? The patent owner may bring a civil action before the RTC, designated as a special commercial court, to recover damages sustained from the infringer. Okay. Other than that, attorney's fees and other expenses of litigation, and to secure an injunction for the protection of his rights. Pagbawal yung violator, okay, to continue with the infringement. Damages may be recovered for the acts of infringement committed in the 4-year period before the civil action is instituted. So, yan po yung measure nung pwede niyang i-claim na damages. Okay? Okay, the loss that is attributed for the acts of infringement committed, okay, 4 years, in the 4-year period before the civil action is instituted. Criminal action for infringement is another recourse. So without prejudice to the institution of a civil action for damages, pwedeng isabay. A criminal action may be filed before the Special Commercial Court if an infringement is repeated by the infringer or by anyone in connivance with him after finality of the judgment of the court against the infringer. The criminal action will be prescribed within 3 years of the date that the crime was committed. Okay? So, nagiging criminal action yung additional recourse mo kasi talagang may intent. Bakit niya inulit? Okay? That's the reason behind this imposition or the possibility of filing a criminal action against the infringer. Okay? Take a look at the period, however, for the prescriptive period po, 3 years of the date, from the date, okay, that the crime was committed. Crime is referring to itong infringement. Let's take a look at the problem. Caesar works in a car manufacturing company owned by Joanne. Caesar is quite innovative and loves to tinker with things. With the materials and parts of the car, he was able to invent a gas-saving device that will enable cars to consume less gas. A gas-saving device. Empleyado siya. Ano yung trabaho niya? Okay? Was it in connection with his regular functions or not? Okay? Francis, a co-worker, saw how Caesar created the device and likewise came up with a similar gadget also using scrap materials and spare parts of the company. Thereafter, Francis filed an application for registration of his device with the Bureau of Patents. 18 months later, Caesar filed an application for registration his device with the Bureau of Patents. Okay, so nag-file silang dalawa. Sino po, okay, ang merong right doon sa patent? Okay, that's the second, second question. Yung first question will be, is the gas-saving device patentable? Ang isipin niyo po dito ay na-meet ba natin tatlong criteria? New, innovative step, industrially applicable. Is it an improvement of a product? Okay. What, if any, is the remedy of the losing party? Sino ba yung losing party dito? Okay, yan. Let's take a look. Is the gas-saving device patentable? Of course, you know that it is. It has met all the criteria that we have set out a while back. The second question is, who is entitled to the patent? And then, what, if any, is the remedy of the losing party? Francis is entitled to the patent because he had the earlier filing date. Yung first to file rule natin. They both applied pero nauna si Francis. What then is the remedy of Caesar? His remedy is to file a petition in court for the cancellation of the patent of Francis on the ground that, okay, that he referring to Caesar, is the true and the actual inventor and ask for his substitution as patentee. Okay? So, cancel na natin, pero since I've already filed an application, okay, I will substitute na lang him in his patent application. Okay? So, papasok siya sa eksena kasi to him, he claims that he is the true and actual inventor. And he is supposed to be the one to enjoy the benefit of patent protection. Okay? So, this is, again, the remedy that a lawful, okay, take note, a lawful losing party, losing in the sense that, of course, applying the first to file rule, okay, pag hindi siya nag-assert ng kanyang claim, okay, mananalo sana dito si Francis. So, huwag matulog sa inyong mga karapatan. Let's talk about patent exhaustion. What is this? Patent exhaustion, the exclusive right of the patent owner is exhausted after the first authorized sale, meaning the purchaser may thereafter use, repair, and resell the product. Okay? So, hanggang saan nag-extend yung kanyang monopoly dun sa kanyang invention. Sabi dito, after the first authorized sale. So, pag magbentahan ulit, di ba? Kasi made available for commercial production already, okay, wala na, na-exhaust na yung kanyang patent protection. However, the purchaser may not reconstruct the product from the parts of the products that were already used. Okay? So, syempre, sino ang may karapatan na gumawa ng reconstruction, dapat yung may-ari ng patent. Okay? Yung disenyo. Hindi po yung purchaser. When does a patent take effect? A patent shall take effect on the date of the publication of the grant of the patent in the Intellectual Property Gazette. Okay? So parang ito yung newspaper record. This is the record of the IPO office on the matter. Okay? So reckoning period po ang tinatanong po dito. Ano naman po yung legal life of the patent? Ano yung period of patent protection? So the term of the patent shall be 20 years from the filing date of the application. Pero yung filing date again, okay, understand it as that which we have mentioned a while back, yung grant, doon manggagaling. Okay? So it would provide the inventor significant commercial gain, yung 20 taon. So within the 20 years of exclusive the monopoly on his invention, baka nakuha na niya yung return sa kanyang capital, okay? Yung sa investment niya sa pag come out with that particular invention. Okay. After that period of time, okay, ito na yung sinasabi natin kanina sa ating unang mga slides, kailangan na i-disclose ni patente kung ano ba, paano naka-arrive doon sa kanyang invention. So what made it new, industry applicable, and innovative, okay, having innovative step when it was applied for patent protection. Okay, excuse me. What rights are given to a patent owner? Okay, so isa-isahin na po natin kung anong naman yung ownership over intellectual property rights, particularly patent. Okay. A patent shall confer on its owner the following exclusive rights. Number 1, where the subject matter of the patent is a product, okay, to restrain, to prohibit, and prevent any unauthorized person or entity from making, using, offering for sale, selling, or importing that product. Where the subject matter of the patent is a process, to restrain, prevent, or prohibit any unauthorized person or entity from using the process and from manufacturing, dealing in, using, selling, or offering for sale, or importing any product obtained directly or indirectly from such process. Okay, nag-extend yan doon sa product, okay, that we come up because of this process. Third one, of course, is the right to assign, to transfer by succession the patent, and to enter into licensing contracts for that invention. Okay? Yan. Napapamana po yung property, kasi property nga to, di ba? It's transferable to whom? Okay, yung kanyang heirs and assigns sa kanyang event na pagkamatay. Let's try to recap. Okay, very important information, the matter of the law on patents. Inventions, of course, meron din po tayong mga mas mababang klase. Utility models and industrial designs may be patented. A patent is granted to the inventor who filed his or her patent application earlier than the others, first to file action, thus simplifying the determination of who is entitled to own the patent. Okay? Tapos, okay, of course, alamin ninyo yung connect natin doon. Although yung may first to file, yung proper, yung lawful na owner ng invention can actually step in and ask for the cancellation of the first registration, first application, and ask that he substitute yung ating applicant. Okay, tingnan natin to. Invention, utility model, industrial design. So, this is the rule that we, of course, have mastered in relation to patent, no? Patent registration for an invention is valid for 20 years from the filing date of the application, subject to the payment of an annual fee. Okay, may bayarin kaakibat, okay, parang tax lang, okay, ng pag ang ating property po ay what, okay, personal property or real property na nakikita, corporeal. Ito, anong payment na hinihingi? Annual fee starting from the expiration of the 4th years, okay, from the date of publication of the application. Okay, you start paying this after 4 years, no? So, on the 5th year, kaakibat po ng pag-own mo ng property, itong intellectual property na patent, ay yung pagbayad ng annual fee. Okay? Annual fee ng ating BPA, ng ating Bureau of Patents. A registration for a utility model, okay, is valid for 7 years from the filing date of the application and automatically expires in the end of the period without renewal. The term of registration of an industrial design is 5 years from the filing date and may be renewed for 2 consecutive periods of 5 years. Okay? So, utility model, industrial design, magkakaiba po yung ating period na binibigay. So, the requirement for utility models and industrial designs, are somewhat less strict than that for patents. Okay? In particular, in respect of inventive step. Okay? And in comparison with patents, the fees are also lower. And the duration, of course, as you have seen, okay, of protection, yung period duration of protection is much shorter. Okay? So, sa utility model, hindi na pwedeng renew yung period granted under the law. Yung industrial design, on the other hand, okay, it can be even before this period of time, pero pwede siyang i-renew. Kaya ano yung maximum period or ilang bilang pwede itong i-renew? Sabi, for not more than 2 consecutive periods. Okay? So, pag sa invention, ang criteria na kailangan natin i-meet is inning. Kaya, no inventive step at isa, industrial application. Sa utility model naman po, ang inaalis po natin dyan ay, yung inventive step at yung new. Parang industrial applicability lang po yung meron sa utility model. Sa industrial design, ang wala lang po dito sa kanya ay yung element na novelty o new. Okay? Okay. Patent under the Patent Cooperation Treaty or PCT. Okay, the duration of the protection that they enjoy, 20 years from the international filing date of the application. If the application was filed pursuant to this international law, then of course the reckoning period would differ. Okay? International din po yung ating titingnan na filing date at hindi po yung filing date in the Philippines if that did transpired. And what about trade secrets? I-relate natin doon sa part 1 ng IPL discussion natin. Natanong dito, what is trade secrets? A plan or a process, a tool, a mechanism, or compound known only to its owner and those of his employees to whom it is necessary to confide it. Okay? This is used in one's business, kaya trade. It gives the employer an opportunity to obtain an advantage over competitors who do not possess the information. It can be a chemical composition, a formulation, ingredients, price list, catalog, specialized customer list. Okay? These trade secrets, however, take note, okay, they are protected, but they are not patentable. Okay? And protected, but not patentable. Bakit siya hindi patentable? Protection is not covered by the constitutional right to information. Protection is not covered by the institutional right to information. Protection is under Section 66.2 of the SRC. Kasi sinasabi kanina, protected siya, pero hindi siya patentable. Yung protection is enjoyed under another special law or laws for that matter. Okay, trade secrets. The ingredients of consumer products are not trade secrets. So Section 77 of the Consumer Act, they should be indicated in the label. Okay? However, ingredients of chemicals supplied to airline companies are not consumer products, kaya hindi natin i-apply sa Consumer Act. Consumer products are primarily for personal, for family, household, or agricultural purposes. And then I now being reminded that the licensure examination syllabus that will cover you when you take it next year, okay, will now mention you learning about the Consumer Act of the Philippines. Ito po, na-relate po din natin ngayon sa pinag-aaralan nyo ngayon special law on the law on patents. Okay? So, yung ingredients of consumer products, they are not trade secrets. They are governed by this particular provision of the Consumer Act. Okay? At ang sabi doon, wala siyang enjoyment nung kanyang right to privacy, information of privacy. I-relate natin sa Data Privacy Act, no? Kasi ang requirement po ng special law na ito, Consumer Act, Yung ingredient po ng consumer na product na yan, dapat naka-indicate sa pakete, sa label. Special case naman po pag sabi dito, airline companies, yung chemicals na ginagamit. Yan. So, move on and continue with the next slide. Cancellation of patents. Who may file? Itong cancellation of patents, we have tried to explain it a while back in a particular problem. Any person. It can also be done by the Intellectual Property Office motu proprio, meaning on its own. Okay? Where to file the cancellation? Ito po yung sa Bureau of Legal Affairs ng ating IPO. If in violation of the Intellectual Property Code. So, administrative case po ito. Pag hindi naman po ito yung masasabi natin na violation ng Intellectual Property Code, sabi dito sa RTC, that is constituted as a special commercial court. Okay? Cancellation of the patents. Then, bago ka pumunta sa korte, you take a look at whether it can be done administratively. Okay? Presented before you are the grounds, which will be the basis of you filing for this cancellation of the patents. Okay. You may say there that the patent is invalid under Section 81, that what is claimed as the invention is not new or patentable, that the patent does not disclose the invention in a manner sufficiently clear and complete for it to be carried out by any person skilled in the art, or that the patent is contrary to public order or morality, or there is failure to make payments of the annual fees or dues. Yan yung mga pwedeng rason natin to ask for the cancellation of the patents. Patent infringement. Yung nabanggit to kanina, no? As another remedy. Okay. Pwedeng civil, pwedeng criminal. Okay. Patent infringement, the making, the using, offering for sale, selling, or importing a patented product or a product obtained directly or indirectly from a patented process, or the use of a patented process without the authorization of the patentee. Without the authorization of the patentee. Yan po yung may elemento ng patent infringement. Okay? Any one of those acts. Siguro nangyari was ginamit mo yung produkto that is directly obtained from a particular, okay, patented product. Without, dagdag natin another element, very crucial, without the authorization of the patentee. Test of patent infringement, we can apply this if we think that there has been violation of yung ating patent protection, merong infringement just in case, then we make use of this. Let's take a look at this test. In literal infringement, the resort is had to the words of the claim. Okay? Doctrine of equivalence, if two devices do the same work, is substantially in the same way, the same result, and produce substantially the same result, they are the same even though they differ in name, form, or shape. Iba mo lang yung pangalan, pero parehas ang ginagawa, so we consider it as equivalent. Yan. So, either under the literal or yung doctrine of equivalence, if that may be the basis for the filing of infringement. Remedies in case of patent infringement, okay, yan, file a civil case for the following purposes. Okay. To recover from the infringer such damages as the court may award, considering the circumstances of the case provided, it shall not exceed 3 times the amount of the actual damages sustained plus attorney's fees and other expenses of litigation. Ito yung tinatawag natin treble damages, no? Kailan po yan ina-allow? This is one case. This is one scenario when we talk about the law on patents and violations of it. To secure an injunction for the protection of his rights, this is number 2. And I think you know what we mean by injunction now, no? To prevent someone from doing anything. Okay. Number 3, to receive reasonable royalty. Ito po yung kita natin, passive income natin sa ating patented inventions. If the damages are inadequate or cannot be readily ascertained with reasonable certainty. To have the infringing goods, materials, and implements predominantly used in the infringement disposed of outside the channels of commerce or destroyed without compensation para hindi na ulit magamit, no? To hold the contributory infringer, okay, what is the liability of a contributory infringer? jointly and several liable for the infringement. So, solidary liability po ang kanyang liability. More slides. Another remedy in case of patent infringement, criminal case. You've seen this a while back. 3 years from the date of commission of the crime for repetition of infringement. Pag first time yan, na infringement, hindi pa pwede, hindi to option in criminal case. Pero pag pangalawa na yan, na ginawa, ibig sabihin talagang may intent para i-violate yung right ng isang patent holder, okay, then a criminal case can be filed. But again, for this period of time, pag wala kang ginawa within this period of time mentioned in the law, then as if we have waived your right to file a criminal action. Okay.